All right, good peeps, let's make this happen. McDonald versus City of Chicago. This case is pretty interesting. It has everything to do with gun rights and our individual civil rights as well. It kind of takes a different twist, right, to what we normally discuss and know about as it pertains to gun rights, gun ownership, and knowing our individual rights as a whole. So let's kind of get into it overall. Um, the one of the main questions here this case discusses and dives into is the concept that can Chicago, the city of Chicago, actually ban handguns in the city itself? So you can clearly see is going after the Second Amendment as it's currently instituted, not initially, but the current concept of the Second Amendment. Now, in 1982, Chicago adopted a handgun ban. It was it wasn't really a ban, but a requirement to register the firearm and possessing an unregistered one. It was a crime, right? So if you didn't register it, and it was unregistered overall, or actually in your possession personally as of right now as an unregistered gun, it was a crime. And in practice, almost all Chicago residents were banned from possessing a handgun itself. Um, and and mainly the concept of it was to try to reduce the number of individuals that were having handguns and using it as weapons, with the hopes that if you want to purchase a handgun, you have to register it, and then we can kind of get a gauge as to where the registered handguns are, as opposed to where they aren't, and actually create a task force to try to get that together. All right. Now, also, the district court ruled in favor of Chicago and the ban. Remember, McDonald sues the city of Chicago, and I'm gonna get to this concept in just a second. But the district court ruled in favor of Chicago and the ban, mainly because of preventative measures to stop the concept of handguns being distributed all over Chicago on an illegal basis. The Seventh District Court of Appeals concurred. In other words, when it goes into the district court agrees. When it goes to appeal, the Seventh Circuit Court of Appeals within that particular region agrees with with Chicago and the Chicago Attorney General as to the purpose and the reason why we have a gun ban in Chicago. Now, McDonald petitioned the Supreme Court, and that petition was granted certification or satori for the Supreme Court to hear the arguments on both sides as it pertains to the Second Amendment and the 14th Amendment of the Constitution. All right, so we're going into the amendments, right? And let's go directly into the concept of what the amendment actually states and means in regard to this particular issue. The Second Amendment is a well regulated militia being necessary to the security of a free state. The right of the people to keep and bear arms shall not be infringed. And we talked about this before, right? About the Second Amendment initially was about about militias, the military coming after you, and to take your possessions. And the way to combat the militia was to get a an individual who, as Jordan Klepper would tell you here, a good guy with a gun to fend off the bad guys with a gun, right? And that no state under any circumstances shall infringe upon that Second Amendment right of the individual to hold, maintain, and use a handgun or any type of gun as it regards to that concept. Now we talked in nausea, right, about the 14th Amendment, that no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall the state deprive any person of life, liberty, or property without due process of law. Now, keep in mind that the Chicago police force and Chicago Attorney General is stating that they're not fringing upon the individual's 14th Amendment because, number one, we're trying to put a handle on the guns that are being sold illegally. Two, we're trying to maintain a registry of property for such gun. And the third concept is that we're not depriving anyone of their liberty to have it, just to maintain it to the point of registering it. We're not trying to deprive it of an individual of this process. Now, the constitutional question at hand is a very simple one. Does the Second Amendment, as is currently instituted, the right to bear arms, apply to state and local governments through the 14th Amendment, and thus limit Chicago's ability to regulate guns? So let me explain to you this way, right? This constitutional question is asking, is the Second Amendment right itself, is this applied to state and local governments to the point where it's using the 14th Amendment as a backdrop to have guns registered, and if not registered, to apply some force or some type of discretionary punishment to said individual in regards of a unregistered gun. So it's using the 14th Amendment as a backdrop or as a secondary source to apply this law into place in the area of the perspective to protect the people of Chicago. Now, this also leads into the precedents, right? So there's also previous precedent in cases that relates to McDonald versus Chicago. Now, in Louisiana, several years ago, or before this case, there was a case called Duncan versus Louisiana in 1968. So this precedent isn't about guns, but about why a portion of the Bill of Rights was incorporated, right? So this case isn't specifically touching the perspective of gun rights. It's touching the perspective of the Bill of Rights. In this case, the justices considered whether the liberty at issue was fundamental and rooted in the tradition of conscience of the people. And in lieu, the court ruled that the Sixth Amendment to the Constitution, a right to a jury trial for criminal offenses, is fundamental to the American scheme of justice. In other words, what this case really talked about was that do individuals have a right to have a jury in as it pertains to criminal court cases? And is this a fabric of American traditional values? And this case talks specifically about this, but not only that, it ruled that the Sixth Amendment is covered and is ingrained in the fabric of America, and that a right to a jury trial for criminal offenses happens to be. So therefore, any case or any situation that deals with a criminal offense, they have a right to a criminal trial. But not just that, in regards of Duncan versus Louisiana, it goes into District of Columbia versus Heller, which is after the fact of McDonald versus Chicago, where DC, which of course we all know is not a state, had a ban on handguns, and the SCOTUS ruled that ban unconstitutional. So the DC took it upon themselves to state, you know what, this case itself, or individuals with handguns, would be banned, right? The usage of or having a handgun is 100% banned, and the thought process of DC versus Heller was that DC isn't a state and therefore cannot be utilized and viewed as a state since the United States doesn't want to adopt it as an actual state. It's just a capital of the United States of America. The justices then stated through the hearings of the argument that specifically noted that did not apply to the states but only to DC because the status of DC as an instrument of the federal government. In other words, the justices in 2008 stated that even though DC isn't a state, it is, and I should have put it in quotations, the instrument of federal government. It is the capital of the federal government itself, of the United States. And because of this, it is not immune to the Second Amendment and to the Constitution itself. That no matter what, you have a right to bear arms if you are an American citizen, and more importantly, that particular land area, that area in which that is owned and utilized by the United States, you have that right to bear arms, to have a gun, whether it's for protection or for hunting or so on and so forth. Now, on top of that, let's look at the arguments from McDonald, and this is some interesting arguments that McDonald and his team of attorneys are making to the Supreme Court. One of them is that possessing a gun is a right. It's not a privilege or a thought. That possessing a gun, handgun, shotgun, no matter what, is a right. And that right predates even the founding of the country itself. Because before there was ever a constitution, you had Europeans coming into America and utilizing guns for their own personal benefit and sometimes for protection. So they used this that even predated the founding of the country. And that guns are an important part of American culture and liberty. So McDonald is stating to you, and his lawyers are stating to you, that not only guns are a fabric of America, it is also important to understand that it is ingrained upon the culture and upon the liberty that America provides for individuals. But it also talks about that almost the entire Bill of Rights is incorporated. In other words, all the liberties that are within the Bill of Rights are fundamental rights and therefore should be incorporated under the 14th Amendment. What McDonald's lawyers are saying are this. One, that the Bill of Rights is incorporated or entrenched within the fabric of America perspective. Two, all liberties that mirrors, right, the Constitution and mirrors us as individuals should therefore be incorporated under the 14th Amendment, because the 14th Amendment specifically talks about the equal protection of law for all people. Black, white, Hispanic, Asian, Jew to Gentile to Catholicism, and so on and so forth. It's all under the 14th Amendment because all people are equal, fundamentally equal. But not just that. If citizens can't protect themselves from a tyrannical federal government, McDonald's lawyers stating that it is only logical that they should also be able to do so against a tyrannical state or local government. Now, the tyrannical state is not just the state of Illinois, or better yet, of Louisiana, the state which we live in, are going to come after us with pitchforks, right, and with other weaponry and take our possessions. What he means is a tyrannical state in which you have individuals that are specifically out to hurt people, to kill people, to maim people, to take things and steal from people, that we as individuals have a right to utilize guns for protection measures as well. Just the same, the Chicago ban obstructs the core right in Heller. So they're saying itself that within Heller itself, to have a gun in your home for protection is important and vital. Because if someone comes into your home and tries to terrorize you, you have a right to utilize some form of weaponry, in particular a gun, to protect oneself from the thief, from the break in person, and so on and so forth. And finally, when it comes to arguments from McDonald, is that if it looks like a duck and quacks like a duck, it's a duck. Just because you don't call it a band doesn't mean it isn't one. By the way, this is an actual statement from the court case itself, right? They're specifically saying, look, just because you don't call it a band doesn't exactly mean it's a band, because within the law which was set up in Chicago, it specifically tells you overall that it's not a ban, right? It is a measure to take guns off of the streets and be able to protect individuals from harm of others. That's an important concept to understand and grasp, right? They're not calling it a ban, at least the city of Chicago isn't, but McDonald and his lawyers are. They say if it looks like a ban and it feels like a ban and reads like a ban, therefore it is a ban beyond measure. Now, while these are arguments that are made specifically by McDonald's lawyers, keep in mind the city of Chicago has their own. But finally, when regards of arguments, their ruling in favor of McDonald does not create a public safety crisis. Guns can still be limited. So McDonald's lawyers are saying, look, if overall you can go ahead and rule in favor of McDonald, quite frankly, you are still looking at the concept of safety. You can still document guns as going on. You can still know what's going on when it comes to gun usage. The perspective is not going to be different. You still be able to enforce laws once laws are broken. Now, the arguments that are specifically made for Chicago are pretty straightforward as well, right? The city of Chicago states that the Constitution and the Bill of Rights are understood as limits on the federal government, not the states. Remember that within the Constitution, specifically the Bill of Rights, it specifically says that whatever rights or laws which are not covered by the Bill of Rights shall also be limited to the states itself. So the states have their own Bill of Rights or the opportunity to do what is best for that particular state, that particular city, that particular region. But just the same, Heller said that the ban on guns was unconstitutional at the federal level only. So the decision that was made by the Supreme Court was made to say that on a federal level, guns itself are that the gun ban itself would be unconstitutional on a federal level, and it does not attach itself to the state level. Remember, the Heller case happened 2 years earlier, and because of that, they're looking at on a federal level. Remember, D.C. isn't a state, right? It is a territory or a region within the United States that happens to be the capital of the United States. And that happens to be on a federal basis, on a federal level. Now, also, Chicago lawyer states that the right to keep a handgun is not a fundamental or established American tradition that warrants incorporation. Just because the Second Amendment states that you have a right to bear arms doesn't excuse the first half of the Second Amendment, where it says about protection of a militia. We aren't granted the concept of guns being our fundamental right. Guns just so happen to be the byproduct of the Second Amendment. Let me repeat that. Guns or handguns just so happens to be the byproduct of the Second Amendment to the Constitution, not a fundamental right that we have. Chicago also states that in the Heller case, the SCOTUS said that the right is not absolute, and that regulations itself are okay. So what Chicago lawyers are saying that, look, the Heller case 2 years ago states that the right itself isn't absolute. It isn't it isn't this grandioso concept itself where there's no regulations whatsoever, that it is what it is. There's no gray areas. There's nothing reading in between the lines. They're saying regulations are okay in order to protect the people in Chicago, which in turn can protect the people of Illinois if this particular concept, this law actually works. Chicago also states that it wasn't actually banning guns, but regulating them. It is different from banning guns to regulations. Think of it this way: if I'm going to ban something, that means that it's not going to happen at all. For instance, I ban students eating in my classroom because, quite frankly, many of my students, including you, you're a little messy. No offense. You eat stuff and then you start, shaking your hands and rubbing your hands together, trying to get all the Cheeto dust off of your fingers, and now you got Cheeto sprinkles all over classrooms. And now Cheeto sprinkles sends off, now you have Cheeto sprinkle residue all over the floor, which now you're going to have little bugs all around. Those little bugs grow into big bugs, and all of a sudden you're going to be eaten. You see how it works? I ban eating in my classroom. However, there are, I didn't, I'm not, there's all, but it's not the fact of regulating, right? I regulate you drinking in my classroom. It needs to have a top on on the bottle itself. You can't just leave it open where if you knock it down, because some of you are very clumsy, water is all over the place, right? I'm regulating that concept. I'm not banning it. I ban eating, not drinking in my classroom. Water or like some type of beverage that's not alcoholic. You know what I mean, kids. Unfortunately, some of you are a little, you know what I mean. So you know what I mean overall. But also keep in mind that states or local governments should be allowed to make their own judgments. Chicago is saying, look, let me be clear. Just like the federal government makes their own judgments, so should local governments and states. Public safety and gun control are important factors of not just the federal government, but they're also important on the state level and on the local level as well. And Chicago has every right to do what they need to do to regulate and reduce the crime that's happening in the streets, the neighborhoods, and areas of Chicago. Now, it ruled on a 5-4 decision. It ruled on a 5-4 decision. And this 5-4 decision, based upon Justice Roberts, Justice Scalia, Justice Kennedy, Justice Thomas, and Justice Alito, are the 5 that ruled in favor of McDonald. Again, these 5 justices ruled in favor of McDonald, and the justices found that the Second Amendment was not only a fundamental right given to all individuals that are born in the United States or happen to be citizens of the United States, but based on historical records, guns were in fact rooted in the American tradition of protection of oneself. Those 5 justices also stated that it is necessary to our system of ordered liberty for individuals to be able to go out and purchase, own, and use handguns in particular. Now, self defense, they also state, is a basic right, and individual self defense is the central component of the Second Amendment. And they cite that because a well regulated militia, at least at the time, that it can be used toward going after an individual or a set of individuals or so on and so forth, that the right to protect oneself, even through the perspective of using a handgun, is our individual right through self-defense. and is central to the enhancement and the understanding of the Second Amendment, in particular, the second portion of the Second Amendment. Also, four of the five justices said that the ruling is not imperil every law regulating firearms. In other words, Justice Robert Scalia, Justice Thomas, and Justice Alito stated that reasonable gun restrictions would be allowed. So we have no problem with providing some sort of reasonable gun restrictions. However, only four justices signed this part of the opinion. So it was not the law, right? So it can't be the law itself. However, it is still saying that individuals have a right to own a handgun without banning it or strictly regulating it, quote unquote. Now, the four justices that dissented upon this and rendered the decision as to this isn't a sound decision is that it's Justice Stevens, Ginsburg, Breyer, and Sotomayor. Now, I want to be clear about this, everyone. This case itself was based upon party lines. This is a party line vote. And this party line vote, it states that Justice Stevens argued that the Second Amendment was adopted to protect the states from federal encroachment, right? Is there to protect the states from the federal government encroaching and trying to get into the states itself illegally. But not just that. It makes no sense to apply that against state and local governments. Remember, Justice Stevens states and argues that this is why it says a well-regulated militia. When the federal government uses their soldiers to come after the individuals within said states, that is when self-defense of a of having guns is important, not the concept of just to have gun just to have a gun. But also, Justice Meyer simply states to conclude, and joined by two others, specifically Justice Ginsburg and Justice Sotomayor, stated that there was nothing in the text, history, or underlying rationale that made it fundamental, nor did it say anything about private defense. So in other words, Justice Breyer, Justice Ginsburg, and Justice Sotomayor specifically tells you this isn't a fundamental right for us as individuals to have handguns or to have any type of gun of that nature. That's not a fundamental right that we have. Justice Breyer specifically states that and criticized the court for transferring the regulation of a private firearm use away from the states. So what he's stating is that you have taken the ability of the states. You have taken away the ability of the state to create laws to try to reduce crime on a state-by-state basis. So he is criticizing the courts by saying you can't state that you can go about saying that state law is essential and vital, yet and still take away a fundamental right of the states to do what they feel is necessary for protection of state residents as well as visitors of one state. You harm the fundamental value of the Ninth Amendment to the Constitution. All right. With that in mind, we're done, right? Quick, easy, breezy, straight to the point in regards of McDonald versus City of Chicago. We know that McDonald, an African American, won his case. And give you a quick background. McDonald is an African American individual living in one of the worst areas of Chicago. Home was burglarized, and not only home was burglarized, other homes surrounding him was burglarized several times over. He went and purchased a handgun and had the handgun to specifically protect himself in case someone tries to break into his home. And that was the precipice of the case itself, right? So we talked about what the case is about overall in regards to the Second and 14th Amendment. We tied in the Ninth Amendment and the Sixth Amendment with previous and present cases that preceded the McDonald versus Chicago case. We talked about the four justices who dissented, and Justice Stevens, Ginsburg, Breyer, and Sotomayor, as to why they voted in favor of Chicago. We also talked about the concept that Justice Roberts and Scalia and Kennedy and Thomas and Alito voted for McDonald and against Chicago. And we also talk about the arguments that was made both by the lawyers defending Mr. McDonald and the lawyers defending the city of Chicago. All right. So with that in mind, look, if you have any questions, any comments, any concerns that you may have, feel free to email me. I'll be more than happy to answer any and all emails that you have. By the way, please, 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 please be safe, be healthy, be responsible. Um, I will submit some information in regards of updates in regards of the AP test for 2020. Major changes that are happening that would be incredibly important for you to get to understand and to grasp. There are going to be some doozies in there, so please be ready for that. And I will talk to everyone later. Again, I will post this as well as some manipulatives for you to read and to look over and to do during this time period which we're out of school. Remember, these are enrichment exercises that I'll be providing you. Please, please try to get these done so you have a better understanding of these court cases overall. All right. That in mind, again, I'll talk to you all later. I will post new updates coming up very shortly, and hope everyone are doing well. And talk to you all soon. Bye bye.